Hello friends, Namaskaram. In today's class, I will discuss the importance of a valid sanction. As we know that if the sanction authority is not competent or sanction accorded is mechanical or cyclostyle, in that scenario, proceeding vitiates. And we could challenge the proceeding on that count. But in absence of knowledge and due to our anxiety to get rid of from the case, we used to file the petition in the routine way. Please avoid such mistakes because your wrong admission, the inconsistency in the pleading might cause a big trouble for you. So basically, we have to understand the legal position, and I will also specify what you can do in your case as well. So first of all, we have to note down certain conceptual perspective. As far as Section 19 of PC Act is concerned, it inter alia deal with the sanction order. Sanction is not required in each and every case of PC Act. It is required in case of Section 7, 11, 13 or 15. Number 3, the authority according sanction must be competent. If the authority is not competent in that scenario, sanction would be illegal. So regarding sanction, we are having two important judgments. One is pronounced by Honorable Supreme Court, that is CBI versus Ashok Kumar Agarwal. Judgment date is 31st of October 2013. In that case, it is specified that the authority according sanction must specify the reason. If the sanction is cyclostyle or mechanical, in that scenario, the sanction will be vitiated and proceedings are liable to be quashed and set aside. Apart from that, recently, Honorable Bombay High Court, in its judgment titled as Bahu Rao versus State of Maharashtra, judgment date is 7th of November 2025, specified that the authority according sanction must be competent. If the authority is incompetent in that scenario, we could challenge the sanction order before the competent court. In that case, there were 3 accused. Accused 1, 2, 3. But accused number 2 has challenged the proceeding. Now the important question arises, why? Because accused number 1 had been died. Accused number 3 had been discharged. So benefit is not given to accused number 2 and that's why he has challenged the proceeding. In the present case at hand, all the accused person has been prosecuted as per the protocol of PC Act. Accused number 2 has been appointed as assistant teacher in a school run by the trust. Even after attending the superannuation, he was retired as headmaster. In the meanwhile, one of the person named as Mr. D inter alia communicated with accused number 1 with a prayer to regular his services. His case is that to regular him on services, accused number 1 has demanded. I am going to emphasize the word accused number 1. Inter alia, he has taken certain amount. It is accused number 1 who has demanded and accepted the certain amount of bribe. And it is agreed that remaining amount is to be given when the alleged work will be done. In the meanwhile, accused number 3 has communicated to inquire about the amount, but he has been discharged. Finally, the matter was reported to Anti-Corruption Bureau. They initiated the verification proceeding, and finally, accused number 2 was caught red-handed. All the accused persons has been booked as per Section 7, 13(2) of PC Act. He submitted that the sanction order is effective, but despite of that, his plea was not considered, and finally, he has moved before Honorable High Court. He submitted that by the virtue of Section 4, subclause 6 of MEPS Act, which means Maharashtra Employees of Private School Condition of Services Regulation Act, the management has power to remove the employee. The Director of Education has no power to accord sanction. Finally, by relying on the legal position, the proceedings had been quashed and the petition submitted by the concerned accused had been allowed. By the virtue of said judgment, we can draw the 5 important conclusions. Number 1, the authority according sanction must be competent. If the authority is not competent, we could challenge the sanction order. Number 2, now the important question arises how to find out whether authority is competent or not. For this, we have to rely on the business rule. And apart from that, we may communicate with our department to know which authority has been given the power to remove us from the services. If the authority is not competent to remove you from services, the sanction accorded will be illegal. If the sanction accorded is cyclostyle or it is in the mechanical way or showing the non-application of mind, in that scenario, we could challenge the sanction order. Number 4, if you are going to challenge the sanction order, first of all, we are supposed to give our submission to the sanction authority. In addition to this, I want to clarify that the sanction authority is not bound to consider your submissions. But if the sanction authority has taken no trouble to find out a prima facie case against you and sanction has been accorded in limine, means in short or in anxiety, then we could challenge the case in the light of judgment of Honorable Supreme Court. Judgment title is Indrajit versus Santosh. Judgment date is 19th of April 2022. Now we are coming on point number 5th. Whether sanction authority has taken into consideration the material facts on record or not. If the material facts are not considered, we could challenge the sanction order as per the norms. So I think that I enlightened you regarding the important subject. See you in the next video. Till then, Jai Hind, Jai Bharat.